Thank you very much, Stephen. Now, I was going to start this by sort of asking a rhetorical question, which is, what on earth could a barrister tell you guys that was interesting and useful, let alone why would I want to sit there and listen to a presentation on guidelines for barristers about AI and tech generally? And I think, other than to say that Alan's initial example this morning about trying to put something into incomprehensible legalese actually wasn't, sounded very straightforward to me. I think Laura answered that first part of the question extremely well and shows that with the right lawyer, in fact, any barrister can actually be potentially quite useful and even entertaining. But really to answer the second part of that question, why are these guidelines of any use to a non-barrister audience? I think the answer can be put into two parts. The first is, for those who are lawyers, although not barristers, or those who use lawyers, understanding the sort of guidance that's now starting to come out that will govern how lawyers use or potentially don't use AI is a very useful thing, I think. And it can be a study of the interaction of law and technology and the way the law itself tries to adapt, usually reactively rather than proactively, and we've tried to reverse that and move proactively here. And for others, it potentially can be a case study where there are some parallels that can be drawn between the challenges and limitations that barristers face or have to work under and the responses that are appropriate for them. And a fair amount of what I'm going to say, I hope, especially towards the later part of the talk, is actually generalisable, well outside of the law, and I hope you find it useful. And what I've done, I'll just see where the clicker works, I'll try to set it out with some signposting so if you get bored you can jump back in at the part that interests you. I won't say that the reason I used the labelling convention I did was to allow a band's name to be used in an otherwise very important legal presentation, but I do have to say the bit in red at the bottom, which is, although I'm here as a barrister who was a member of Banco Chambers, and although I am a deputy chair of a committee of the Bar Association, which I'll come to just in a sec, everything that I say is my own opinion and don't attribute it to either Banco Chambers or to the Bar Association. So I'll start off with the what. You'll see, possibly illegibly in the written print, under the heading of the document, which I've put out in the bullet point on the right, the Bar Association released some guidelines about a month ago now. As far as we can tell, it's the first AI guidelines or the first AI-specific guidelines of any Australian bar or solicitors association. But in fact, as far as I can tell in my brief researches for this talk, it may be one of the first, if not the first in the world. The obvious suspects, the California Bar Association, the State Bar of New York, and the English Bar Association don't seem to have any published guidelines yet that I could find. They each do have some committees or people looking into it, and I'll quote from a couple of the things a little bit later, but it is very much on their minds. There was a talk just after these guidelines came out by the Master of the Rolls, so a very senior legal practitioner, a judge in the UK, Sir Geoffrey Voss, in a law reform lecture, targeting some of these issues exactly the same way that we have, and I think answering them the same way, and I'll quote from him a little later. Now, I put the guidelines up. Unfortunately, there's not an easy link that I can give you to the Bar Association's site, so I've just put up my own intermediate link that gives you the document and gives you the real link if you want to go to it. But hopefully what I'm saying can be understood and said without actually having to have a copy of the guidelines in front of you. So onto the important stuff. Who is the Bar Association? It's a professional association of barristers. It's for practicing barristers, but also associate members and judges. It promotes the public good in relation to justice and the provision of legal services, and it achieves this in various ways, including by trying to maintain and maintaining high standards of excellence for barristers. And I think I say, as my own personal opinion, these guidelines tend towards that, try to achieve an aim, which is how should barristers, how should lawyers use technology, especially something like this, in their practice. Now, the association has a number of committees. One of the ones I'm lucky to be a part of is the Media Information Law Technology Committee. Our terms of reference, and I won't read them out, cover this area in particular, and that's why the committee was at the forefront of drafting these guidelines. Now, why? Should be an obvious question, but if you're thinking about it before you seek to put in anything into writing or promulgate anything as a guideline, you should have an idea and understanding what is it you're trying to do, why should you do this? And I think the answers are fairly obvious. There's been, as you can all know, much better than I probably, increasing interest over this topic, especially over the last 12 months and even more especially over the last 6 months. Even your usually tech-avoidant barrister/lawyer is seeing these in their headlines in regular papers. They don't have to go to a special technology section to see it. They're getting things in the inbox from the various providers, including LexisNexis, bringing it up as something which is being offered to them. And you're obviously going to expect to get inquiries then from barristers. What is this? What do I need to know about it? Can I even use it? There is a lot of coverage, press coverage of these problems, and one that I'll come to was obviously this Marta case, Marta and Avianca in the US, that was unfolding even as we drafted these, and we in fact updated them to include some material from it to show these aren't theoretical objections, these are real problems that can arise and have arisen and can cause difficulties for practitioners, just like in any technology. Of course, the other reason, I think my own personal opinion, and again, don't attribute this to anyone, if you were to draw a Venn diagram between lawyers and technologists or technology, I think you'll probably all would agree that the intersection is very, very small, unfortunately, although getting better. And I think you've probably all seen the "Your Honour, I am not a cat" clip, which I think is now 2 years old or so, without casting any shade on anyone. I think tends to illustrate the fact that sometimes the profession has a little difficulty adapting to technology. Now, I mentioned that Marta and Avianca case. This unfolded from submissions that were made in March, so we're only talking a few months ago and only a couple of months before these guidelines were released. And you'll see I've got an excerpt from it here, and you'll see a reference, paragraph 15 of the submissions of the plaintiff. Here you've got cases that are referred to, Shaboon in Egypt there, with a very good-looking citation and sets out what it says the case held. You've also got other references to other cases, a Martinez case cited into Texas, Estate of Durden, KLM Royal Dutch Airlines out of Georgia supposedly, quite detailed, very useful for the plaintiff there, happened to say exactly what the plaintiff needed to get over the hump that they were being confronted with in terms of could they bring this case in federal court, given the problems that they'd had with the statute of limitations. You have to sue within a year, I think it is, otherwise you can't keep going. You get to the, I probably shouldn't call it a train wreck unfolding, but it's something like that over April and May, when it starts making headlines, when people are looking at the docket and hearing arguments being made that the respondents, the airline, write back in their brief and say, we have a problem, we can't find any of these cases that are being cited against us that supposedly cause us to lose the case. What's going on here? And you end up with the opinion, and again, the date that these guidelines were initially approved, summarising from the judge's opinion, although plaintiff ostensibly cites a variety of cases, the undersigned has been unable to locate most of the case law cited. It impliedly asserted that certain cases were non-existent. And then later in the opinion, one of the lawyers that are involved testified at the sanctions hearing. Yes, he was up for sanctions and he was sanctioned for all of this, which I'll come to back to in a second. He reviewed the submission and didn't read it before he forwarded it on to the other lawyer who was, I think, more responsible. Mr. DeLuca was the postbox. Mr. Schwartz was the person who couldn't use the AI. And then, as it was later revealed, he'd used ChatGPT, which fabricated the cited cases. And, you know, you watch the train wreck keep going. You get the analysis, I think quite pithily and well stated there at the end. The Peterson decision doesn't exist, and the citation that was supposedly given is an unrelated case. Ditto when you get further down, in para 35, Shaboon and Martinez and Durden decisions contain similar deficiencies, i.e. they don't exist. So the cases that were cited to the court to support the legal argument and could have resulted in the court finding for the plaintiff were non-existent. In other words, the plaintiff misled the court. When you actually read the decision, if you're sort of sad enough to go about reading legal decisions, one of the cases is, this Varghese case, supposed case, is annexed as an appendix, and you'll see that there's the watermark across the back, do not cite or quote as legal authority. Reason, it doesn't exist, it's not a true legal authority, it was all made up. But when you read it, if you're not sure about what you're reading or you don't really look into it, it actually looks quite persuasive. It seems to read like a proper case. You've got the usual format, you've got some judges, you've got a statement of the preamble as to where this case is coming from, you've got some facts that are given over the page, you start with some citations. But it's at that point, and I'll come back to this, that any proper lawyer should actually take pause, because you'll see that the first case cited there is in re RIMSAT on the bottom right-hand side. I went into that case and opened it up, and it's a real case and it exists, but the quote that's attributed to, in this case, doesn't exist. That is, it purports to cite a case that does exist and gives you some text, but that text doesn't appear in the case. So unless you go back and have a look at it and find it, it seems okay. If you go back and look at it, red flags should be going up everywhere. Why can't I find what this case supposedly says the other case contains? It's just not there. And that, I think, in a nutshell, is obviously in lights. Why do you need to have guidelines like this for practitioners? I did find a useful document from the State Bar of California going through trying to find out what they were doing about AI and guidelines and ChatGPT generally. And they did a survey, and there's a panel, I think it's called, that's looking into AI, and only 256 participants, so reasonably sized but not enormous. But you'll see some interesting numbers, which is 28%. I'd say obviously the older practitioners never used it, not planning to. 34% never used it but open to trying, so at least at the moment that's 62% that haven't actually got their feet wet. Then you've got a quarter, 25%, I've tried it a few times, and then the ones that start to get a bit worrying at the moment, 7% I use it about once a week, 6% I use it daily. Okay, it shows, I think, we're on the beginning of the uptake. People are just starting to use it, and if people want to avoid the fate of Mr. DeLuca and Mr. Schwartz in Marta, they need to actually think about what it is that they're using. So with that, I'll move on to that subject, which is, what are we talking about here? I won't give you, unfortunately I'd love to, but it's way out of scope and we don't have enough time, much more other than a summary of the key aspects of ChatGPT. I'll leave the details to others. As you know, it's a large language model, which is a technical term of art. Important part for the bar and for guidelines for barristers and for the solicitors, it's trained on data sets. And as you know, the power of an AI depends on the usefulness of the data set, a large amount of which comes down to the size and the variety that's in it. And the relevant amounts you've got there are, from ChatGPT 1 to 4, you've gone from 5 to 570 gigabytes of text. And so, of course, you say, what is that text? What is it being trained on? Went back and found an interesting paper which came out with the introduction of ChatGPT 2 about what these language models are. The two last authors, Dario Amodei and Ilya Sutskever, and correct me if I'm wrong, but I'm pretty sure these are the two that are acknowledged as the fathers of ChatGPT. They're the two that seem to be the key movers behind it. And I won't read it out other than to note that the first red flag to anyone who's got a Reddit account is the selection criteria for the data set starts off at 3 comma on Reddit. And if you've ever posted on Reddit, 3 comma is not exactly a very high bar. More importantly, what you then get is you get a resulting data set, web text, you've got a whole bunch of links, you end up parsing that, doing some cleaning up over it, and you get a data file of slightly over 8 million documents for a total of 40 gigabytes of text. So that's where your data set comes from. So the first thing you need to do, and I'll come back to this theme, if you're talking about AI, at least as someone who's trying to semi-regulate it, you don't treat it as a black box. It's not some magic thing. And I think part of the problems that the practitioners get is typing something into a computer and getting a response back makes you think that there's an intelligent entity on the other end. It's the ELIZA program. It's the basis of the Turing test. It's what makes you think there is someone alive or something thinking. And I think that that misleads people. When you actually realise what it is, and I'll come to that very briefly, you actually see that you are looking at a sort of semi-curated data set of web pages and you don't know what they are. You don't know where they came from other than they were on Reddit. You don't know what was excluded or changed when they sanitised and modified the data set. Now again, without hoping to stray into anyone else's sort of territory, the key aspect of the training of a large language model is it really gets down to what words, and brackets, to anyone that really knows what they're talking about, it's actually tokens, which can be less than words and usually are not entire words, but for lawyers, it's easy to think of it as words. It's the tokens and the token order, the words and the word order, in the texts on which the model is trained. And you'll see, I picked what is actually probably a bad example because there is so much dissimilarity, but you can see that even something as crazy as Dickens has some structure to it, and what the model will be looking at is what words follow the "it was the." And you'll see there's a bunch of different things. There's a bit of commonality. There are two, it was the epoch. It was two, it was the age. But what it's looking at, obviously it's much more complex than this, is what words follow what other words. What you then need to know in order to sort of get onto top of trying to regulate or advise about AI is that you have a transformer, that's the T part of ChatGPT. The operation of that transformer draws on those words and word order, and it's the probabilities to produce what's coming out. And I will underline, probably mark me as a heretic, but it's not intelligence, it's not creative, it's statistics, because the AI doesn't think. And the content that's produced depends on what the data set contains. So if you've got a data set down the bottom here that's been trained on stories, you'll get Once Upon a Time. If you've got movies in there, you'll get Once Upon a Time in Hollywood. If you've got musicals, you get Once Upon a Mattress. If you've got poetry, you might get Once Upon a Midnight Dreary. But all of those things depend on those source materials being in the data set. If it's not trained on one of those, you're not likely to get one unless someone else somehow randomly has fed it in. And I've reiterated there, the AI does not think. It might fool you into thinking that it's thinking. Yeah, okay, you know what I mean. But what it really does is output words based on probabilities, and it's all statistics under the hood. That's how at least I like to think of it. And what that really then means is, when you get into the detail of it all, once you understand that you are operating a statistical-based program, brackets, that also works and turns heavily on what you feed into it in your prompt, and you saw that this morning when Alan was feeding in lots of prompt material to get the answer, that's critical to the operation of any of these sorts of chatbots. Once you understand that, pretty much everything else I'm going to say and the guidelines I think make sense. So the detail, and I'm not going to, I think you'll be glad to know, get into the detail of the Barristers rules or the guidelines themselves. The take-homes are, barristers are bound by detailed ethical rules. There's actually a piece of legislation in every state. It's generally fairly common, but each state does have its own peculiarity sometimes. Those are generally expressed and they apply to AI content just as much as they apply to anything else, getting something from a book. And I've underlined some of the key points. One of the early rules talks about you've got to act with competence and diligence. Okay? You've got to exercise a forensic judgment and give advice independently. You've got to act in the interests of the administration of justice. And already, just by saying those two rules, you should be able to say, does that mean you should do what the guy did in Marta and just send something to the court that you haven't checked, that you've gotten off a box somewhere that's been spat out? It's not going to work. And to pick up, I think, Neeti from this morning, if you start thinking of AI as an enabling technology rather than a replacement of a human, you start to be in the right spot. And what I think the obvious thing to guard against is any legal practitioner, or in fact any professional, saying, I can outsource my job, I can type all of my work into ChatGPT, I can paste the answers into what I give to clients, and I can go to the beach for the rest of the day. And I think that's the sort of thing that I honestly don't think I know any person who would actually think that way, but I think the temptation would be there for at least some. A few of the other rules, again, you can see where this is going. You mustn't deceive or knowingly or recklessly mislead the court. And that's sort of the basis of the sanctions. The very minimum that the fellows did in that Marta case was by using a new technology, not knowing its limitations, getting some answers out, not testing those answers, not even testing to see if the quotes that are supposedly in the cases were actually in the cases, and not checking that the cases that were cited actually existed. That's got to be, at least in my opinion, getting very close to, if not recklessly misleading the court. I'll skip over Rule 35, which is really talking about doing your best. That's really something that's important for a barrister. What it means is you can't just do a quarter, what job, and farm something out to an AI. You actually have to put the hard yards in yourself and do it. And that is picked up again in another rule. You must exercise forensic judgments called for during the case. In other words, you must actually make sure that what you tell in the court is true. I think another area people haven't yet fully gotten across is it's not just ethical rules that govern barristers that cover this area. You owe a duty of care. Any professional providing services for reward to someone else owes a duty of reasonable care. Take care to make sure that they're doing their job properly. And sticking something into a chatbot, getting an answer out, is not going to satisfy that. So this is an area I think there will be more about. Professional indemnity firms, insurance firms are going to have to grapple with this to start telling solicitors, for example, just as you have to watch out for expiry of statute of limitations so that you don't file your client's case late, they lose and you get sued. I think there's going to have to be some sort of similar guidelines to cover that kind of the problem that's shown up in spades in Marta. Moving then into the content of the guidelines, but without getting into detail, and I'll just give you the headings coming up and a few comments on each of them. The general suggestions that are made are understand the weaknesses of what GPTs are, and that's why that short spiel that even a lawyer can understand, don't hold it against me, about how these things work and what their limitations are and what they're really doing is so important. Because if you think it is something that is truly alive and intelligent and giving you the right answer because it's brilliant, you're going to be in for a real problem. That leads into that GPTs are not reliable. You have to verify the accuracy and the reliability. And I mentioned that the Master of the Rolls in Britain gave a speech on this recently, and I'll quote what he said. It's Sir Geoffrey Voss, because it's absolutely correct. That any lawyer using an AI to help write their submissions will need to check them very carefully, because it will be they who are responsible for their accuracy, not the AI. Lawyers may find that the time needed to check the work of an AI is greater in some cases than writing the submissions themselves. And I would endorse that. And without throwing any shade at Alan, his thing this morning generating the report for ANZ included a line, I think you caught it, ANZ is not involved in any current litigation where there could be more than $50,000 awarded against it. And my initial radar going up is a national bank involved in mortgage disputes and possession disputes where there are costs orders potentially easily exceeding $50,000 is likely to have some kind of exposure above that. So just blindly relying on what the AI spat out would be a starting point. Sorry, what the AI spat out would be a starting point. Blindly relying on it would be disaster. One of the other, I should just address the bottoms. One of the things that we've also stated is it's prudent to keep a record of any decision to use an AI. If you're sued later on, the old adage for medical defence was good records, good defence, poor records, poor defence, no records, no defence. If for some reason it becomes an issue later on that you shouldn't have used an AI or the version was immature or what you used wasn't up to the task, having records as to what you used, where you used it, why you used it. We also suggest keeping a record of the questions you ask, the prompts, and the choices that you made. Obviously the output as well you'd have to keep. And also what was in the terms of service. And I'll come back to this, but these terms of service for these services change. And you want to make sure that what you agreed to back 2, 3, 4 years ago, if it becomes relevant, is actually preserved because it may well have moved on. And these are then sort of the subsets, the various points, and they draw largely on what I've said before, so I won't repeat them too much, but the known limitations of all GPTs, all generative transformers, including ChatGPT, is you have a finite data set, and you've heard the word hallucination. They can fabricate content. And you see the fabricated content, I had it up on screen, it was the non-existent cases. It's easy for it to do, and because it looks plausible in terms of language and content, and it doesn't say, I'm out of ideas, I don't have anything to draw on, I'm making something up. If you don't know that, you're going to be working with material that's unreliable. The currency, more important for law, I think, than possibly some other areas, version 3.5, which is the current free version, is only current to September 2021. So for law, where decisions, potentially even laws themselves, change relatively quickly, not having the last 2 years of material means you're not up to date. There could have been something that was said that totally changed everything previously or added something new. If you don't know about that, any advice that you do based on what an AI spits out is going to be flawed. Hallucination, I've mentioned, it was so important we dealt with it in a separate little space. People have to know that hallucinations exist, and I actually think that one of the big challenges in legal-based AIs is going to be not so much guardrails for safety, but guardrails for accuracy. Because if you're relying on them for facts, for information, you need to be sure that it's telling you this is something that is true and that is correct. And if it's not telling you something that is true and it's extrapolating or it's just making something up, you need to know that. Next, this is an obvious one. Be transparent with your client. You are being hired as a professional to put your own expertise, thought, judgment, forensic instinct into it. You're not being paid to delegate it out to something else. If a client says, well, I can access that for free, why do I need you in there? I can just get this answer. If you don't even tell them that you're doing this, they might have a very legitimate gripe after the fact. And that can manifest not just as a lawsuit for lack of reasonable care, it can be a complaint. These ethical obligations were breached. And I'm on a committee that deals with those. And one of the consequences you can get, in addition to the cautions and reprimands, is there are barristers that sometimes you end up having action taken against them and sometimes being struck off for doing things that are not allowed to be done, contrary to their ethical duties. Obviously, you can't, charge time that you don't spend. I think that was the other obvious takeaway from these. If you're subcontracting this task out and it takes you 5 minutes to check, well, A, 5 minutes is probably not enough and you haven't checked it properly, but B, you can only charge for 5 minutes. This is what junior people used to do, but now it's being done instantaneously. It can't be charged for if you're a solicitor. And this is one of the challenges I think that are facing law firms is tasks, document and time-intensive tasks like discovery, data rooms that used to be performed by in-house solicitors for a long period of time at relatively high rates can now be outsourced for a very, very cheap amount. Confidentiality has been dealt with, which is you need to know that if you enter material that's confidential to your client or worse, privileged, by typing it in, hey, here's my problem, give me an answer, if the model owner might incorporate that, and I can't remember who said it earlier, I think it was 2 talks ago, it might be spat out to someone else. It's not just your precedents and your contracts that they might see, it's the facts, what your client has told you, confidential information, privileged decisions, things that you would otherwise never let out of your sight. And there's a very specific prohibition in one of the rules, and I've given some of the analogues for the other big jurisdictions, preventing barristers from doing this. This has also been touched on this morning. Your data set might contain biases. Anything that is produced from a data set that contains biases is likely to reproduce those biases. Problem, barristers are actually heavily regulated on things that they must not do. And material that contains biased or otherwise discreditable statements, and there was a version, I think as you know, of ChatGPT that was withdrawn as being too dangerous because it drew on some Reddit comments that actually had some white supremacist statements in it and it was reproducing them. Because it was in there, it comes out. Lastly, again, I think also this has been dealt with in part. There are intellectual property considerations. There's the obvious one. If your data set contains material that's subject to someone else's copyright and you put that out under your name, you may well have infringed their copyright. There are currently lawsuits, including I think by Harry Potter, the publishers, saying ChatGPT was trained on Harry Potter. Everything that's been produced from it actually is in some way or in part attributable to a breach of copyright. There's been an infringement. You may get a defence, but you wouldn't want to rely on that. And the other point, I think, David, your request to use the copyright for the crest may actually not be necessary. There was a decision in the US, one of the Thaler cases, he's a guy going around getting the legality of AI sorted out. The wording of the US Copyright Act, and I think ours, requires a human author. And the counterpart is patent litigation. It didn't make the High Court here, but to be an inventor under the IP legislation of a patent, to get a valid patent, you need to have a person. So his lawsuit's testing whether you can have an AI inventor. So far in the US and the UK, I think in Canada, have come to the answer, no valid patent. AI can't be a patent inventor. And then finally, the obvious point as well, privacy. If the material on which a data set was trained include private information of someone else and you reproduce that unknowingly, you might be in trouble. There is a lawsuit targeting that in the US as well. and it involved personal information of minors. And I think David will say something a bit about that, so I won't tread on his toes. I think, and finally, one illustration of the potential difficulties that you get using an AI. You ask it a simple question. I'm a lawyer, I've got a debt. How long do I have before my client is time barred from suing? So you type in, what is the limitation period on a debt? And you get an answer that's correct, but nuanced. It depends on, quote, underlined there, the type of debt involved. And then it says, in general, the limitation period is 3 to 6 years. Now, just as an example of how dependent these things are on their prompts, you ask it a slightly more detailed, targeted prompt, what's the limitation period in New South Wales? And aha, you finally turn up the important point, which is for some debts, the limitation period is 12 years. That's when you've got a mortgage, and that includes a charge. So if you don't know that, and I've actually had a case literally brought to me where the solicitor says, I did the pleading for you and now we've got to run the case, and they admitted everything and said, however, you are suing 9 years after the debt was supposedly incurred, you are time barred. And you look at it and you say, they have pleaded that the loan was secured by a charge. Oh yeah, they did. It was. A charge is a form of mortgage. The limitation period is 12 years. They have admitted the entire claim. They have no defence. Okay, that's the sort of area you can get into. And then I think just to close, it wasn't on the list up front, but I had to put it in. That's how I see it. It can do a lot of the work, it just doesn't quite get there. All right, does any... I think I'm over time, so I don't think there's any questions. If you have any and you don't want to ask... Oh, sorry, absolutely, yeah.
With the way, one of the most complex legal cases in Australia at the moment is the Generative Transformers, where all the families come together and virtually every legal firm in Australia is working on this case. Is there ever a position where you can see in the future where all the data, and it's going to be incredibly difficult for a judge to determine which way to go? Can you see the way in the future, the way we're heading now, where a judge can potentially get all the data from both sides, put it into an engine, and then he can ask the question, which way should I decide?
It's a really good question. People have been working on that since the 80s. In the 80s, you had a bunch of factors that you had to answer, and you say, you know, does the case involve X? Is the plaintiff, and from the best of my memory, this is one of the questions, is your plaintiff an old lady older than about 65 or 70? Because when they did the analysis, they found that little old ladies presenting in court had statistically higher levels of success, and it was one of the things that actually differentiated in the outcome. But it all comes up against, I think, the problem that a judge's task involves and requires exercise of judgment, hence the name and the word. That often involves things like a concept of reasonableness. You know, is what the person did reasonable or not? And that's the area where I think you might be able to get something to go, I think the word is ontologically, you can look at a whole bunch of past decisions and say statistically these things made it more likely that the judge says it was or wasn't reasonable. Where I don't think you'll ever get a good answer, and this is just me predicting, is dealing with a new case. For sure, I think. I don't think you're going to ever be able to replace that element of thinking and discretion. That has an intuitive aspect, there's a moral aspect, there's a feeling aspect, there's a this feels unjust, I think, which I don't think you could ever replicate properly, and I think it's necessary. And I also think, even on the cases where you have had similar cases, but you've got a complex one, and there's a lot of factors going different ways, I think that's the other area, and that's a lot of commercial cases. That's another area where I think you'll never really get a satisfactory sort of automated response, and I think you'll always will need a human in the loop. You may be able to use it to summarise sort of tables or summaries showing success and failure, strength or weakness of a case, but I don't think I'd ever trust it to be good enough to actually do the decision or even get you close. I hope that answers it.